Hello everybody, welcome to part 4 of the Australian Employed Workers Union's online advocacy course. This part is called How the Compliance System Works, and it's really the heart of a lot of the work we do is helping people deal with the compliance system and when they get cut off their benefits, what should they do? It's probably the most urgent and necessary work we do is dealing with people who get cut off their dole. And as we know, people are just one financial penalty away from extreme financial distress, which could push them into all sorts of horrible situations. So it's arguably the most important work we do is advocating for people once they're getting threatened with a fine or suspension. So first, I just want to talk a little bit about how the compliance system works and give you a brief overview of what it looks like. So this graph here is quite complicated, but I'll talk you through it. Really sort of gives quite a broad overview of how the compliance system works. So let's start at the beginning. An unemployed worker fails to meet a mutual obligation requirement as stated in the job plan without a valid reason. And when I say valid reason, that means that the unemployed worker hasn't called up in advance to say that, for example, they couldn't attend an appointment. They haven't made an arrangement with the job agency to say that, they're not going to be able to attend whatever that activity is. So that's called a valid reason when an unemployed worker calls in advance. This is different from a reasonable excuse, and a reasonable excuse is something where the unemployed worker has to call afterwards and then make a reason or inform the job agency what the reason was for them failing to miss that particular appointment. So two different concepts there. Valid reason is when you inform your job agency before the appointment that you can't attend, and reasonable excuse is when you inform them afterwards. So that's something just important to remember. So let's go back to the start here of this compliance process overview. Unemployed worker fails to meet a mutual obligation requirement as stated in the job plan without calling in advance and giving a valid reason. The first step then, this is how the system is meant to work. The first step is the job agency is required to contact the unemployed worker on the same business day as that failure occurs to determine if the unemployed worker has a reasonable excuse. Now, at that point, once the job agency has made that call, the job agency determines whether or not a reasonable excuse existed or not. And a reasonable excuse is defined quite vaguely by the deeds and the guidelines. It's essentially what a reasonable excuse is what a normal member of the public would accept as a reasonable excuse. So it's very, very vague, and there's a lot of discretion there for job agencies to determine whether or not they think it's a reasonable excuse. But in the deeds and guidelines, it's basically defined as whether an ordinary member of the public would accept it as a reasonable excuse, and secondly, whether or not an ordinary employer would accept that as a reasonable excuse. So they're sort of some broad parameters around what a reasonable excuse is. So if the job agency decides that the reasonable excuse was valid and they accept the reasonable excuse, they find it exists, then the suspension will be lifted, that particular infringement will be lifted, and then an arrangement will be made between the unemployed worker and the job agency to attend the next appointment. If the job agency finds that no reasonable excuse occurred, or no reasonable excuse exists, from then the job agency would send what's called a participation report to Centrelink, which is essentially kicking the infringement or this compliance order, passing it on to Centrelink. Because it's important to remember that under Social Security law, job agencies actually can't make compliance decisions. Every compliance decision needs to be made by Centrelink. All job agencies really do is they pass on reports to Centrelink, and then Centrelink make the final decision. So in this case, the job agency would pass on a participation report to Centrelink, essentially recommending the appropriate penalty be imposed. Then it's up to Centrelink to start this process all over again, and then they try to call the unemployed worker to see if a reasonable excuse exists, and they try to see, or basically make sure that the job agency has done its job. So this whole the system's designed to try to have checks and balances so that job agencies don't just start penalising people without making the appropriate attempts to contact people and see if they have a reasonable excuse. So then Centrelink, at this point, required to contact the unemployed worker, and it's basically within 48 hours, 24 to 48 hours of receiving that participation report, they're meant to contact the unemployed worker to decide if a reasonable excuse exists. And then if DHS finds it exists, then the suspension is lifted, and the unemployed worker then is told to contact the job agency and work out the next activity date, or it'll essentially just, the normal aspects of the job plan would continue. If DHS, so Centrelink, finds a reasonable excuse does not exist, then the penalty is imposed, and the unemployed worker can then appeal that penalty to Centrelink, and then that goes through the appeal process. So that hopefully gives a broad overview into how the system is meant to work. So that's very important to emphasize. This is how it's meant to work. There's two levels of checks and balances where job agencies are meant to contact unemployed workers to see if a reasonable excuse exists, and then Centrelink are also meant to contact the unemployed worker to see if a reasonable excuse exists. What we're seeing overwhelmingly on the ground is that that's not happening. Job agencies aren't calling unemployed workers to see if a reasonable excuse exists. In most cases, unemployed workers get a text message at about 5 minutes to 5 stating that they have failed to meet an element of their mutual obligation and that they should contact the job agency to sort it out. So right there, they're not really doing their job properly. They're just sending a text message trying to get people to call up, but most people would receive that message and they'll probably read it a little bit after when they get it, and then by then it's too late. The job agency's closed, so then they have to call the next day. So it's very, very insufficient, completely, really horrible approach that a lot of job agencies take, where they give people very little time to actually call back, and essentially they're not giving unemployed workers the opportunity to inform the job agency if they had a reasonable excuse. And then at the Centrelink level, we also are finding overwhelmingly that Centrelink aren't contacting unemployed workers to see if they have a reasonable excuse then. So what this basically boils down to is that job agencies, they pass on participation reports to Centrelink without making the appropriate attempts to find out if unemployed workers have a reasonable excuse, and then Centrelink look at the participation report and essentially rubber stamp it, and then the penalty is imposed. And this is a completely broken system. And this is where the unemployed workers union needs to step in and start advocating for people. So here's just some background over what I just told you about the job agencies must contact you. So here it states in the deed that if there is no valid reason, which as I said before is the job seeker or the unemployed worker hasn't called in advance to tell them that they can't attend that particular requirement. If that doesn't exist, there's no valid reason, as soon as possible on the same business day, the job agency must attempt to contact the unemployed worker to assess if they had a reasonable excuse for not complying. So that's very, very clear. They must contact them on the same business day. And that contact should be done by phone and they should be speaking to them. But a lot of job agencies try to get around that by just sending a text message because they're completely understaffed and they also can't really be bothered giving unemployed workers that opportunity to inform the job agency they have a reasonable excuse. Then secondly, we have proof here that says Centrelink must contact you once that participation report gets sent across. And this is a quote from a Senate inquiry, and the person representing Centrelink, Mrs. Ryan, said that we are obliged then, under the law, to contact the job seeker and give the job seeker the opportunity to explain. And a bit further down it says that they are required to call them, make contact 24 hours to 48 hours of receiving that report. So this is how the system is meant to work, but as I stated before, this isn't happening. And what we're seeing there basically is a broken compliance system. And one of the main reasons for that is penalties are completely blowing out. So as I went through in part 1, there are 2.1 million penalties imposed on unemployed workers per year. 2.1 million times that the job agency is meant to contact the unemployed worker, and when they get passed on to Centrelink, that's another 2.1 million occasions where Centrelink are meant to call the unemployed worker. So you can get an idea that job agencies and Centrelink just haven't got the resources in many cases to call that many people that many times, and this is quite deliberate. Now I'm going to go through some of all of the different types of penalties that can be imposed on unemployed workers. So the first type of penalty I'm going to go through is called the connection failure participation report. So this is a type of participation report that Centrelink would receive from a job agency. If you remember the graph before, so the job agency are meant to work out whether a reasonable excuse exists or not, and if they find a reasonable excuse doesn't exist, then they're going to be sending these sorts of participation reports through to Centrelink. And there's a range of different participation reports they can send through, and in fact the government want to create more different types of participation reports, more ways that job agencies can penalise people. But for now, here are the participation reports that can be sent through. So this first one is failure to attend appointment with an organisation other than the provider without a valid reason or reasonable excuse. So when this report is submitted, DHS or Centrelink will suspend the job seeker's income support payment and set a reconnection requirement in the department's IT systems. Agreement to attend this appointment will lift this payment suspension. So in the scheme of things, this is quite a sort of not a very serious penalty, because it starts off with a suspension and it only leads to a financial penalty when the unemployed worker doesn't attend the re-engagement appointment. And before we really get into the real nitty-gritty of all these participation reports, it's worth talking about what a suspension is. So a payment suspension is by far the most common type of penalty. In that figure I discussed earlier, 2.1 million, about 1.8 million of those penalties were suspensions. And what a suspension means is that the payment is suspended until the unemployed worker reaches out and re-engages, essentially. So once the unemployed worker re-engages, then there's full back pay given for those dates of what's called non-compliant. So over the dates where the unemployed worker was cut off, that's called the non-compliant period. And once the unemployed worker re-engages after that period of non-compliance, then there is full back pay. So when you look at it from that perspective, there is no money lost with a payment suspension. Where it gets really dangerous for unemployed workers is when they get suspended, let's say, the day before they expect their payment, and that suspension means that their payment will be delayed until they re-engage. So there's no money lost, it's just a delay in the payment. So that's the worst case scenario with the payment suspension, is that an unemployed worker will get their payment delayed, but there's no money lost. So in the scheme of other penalties, it's not a particularly serious penalty, but it's still potentially, very, very disastrous for an unemployed worker who's relying on a payment to come in a particular day. But as long as they're not near their payment date, then the unemployed worker hasn't got that much to lose. It's just more frustrating having to go back to your job agency and try to work it out with them. So with this penalty, the failure to attend an appointment with an organisation other than the provider, which is basically a training organisation or work with an organisation, it's only going to be a suspension of payment unless the unemployed worker fails to re-engage with a follow-up appointment, which is another appointment set with the training organisation or with the third-party organisation. So suspension of payment with a possibility of a financial penalty. So that's one that can be quite easily managed with an unemployed worker just simply re-engaging. And that's something that can be more difficult sometimes, but as I said, not a particularly serious penalty. The next penalty is failure to enter into or vary a job plan. This penalty is submitted by the job agency when the job seeker attended their appointment but did not enter into a job plan or did not accept their job plan in the required time frame. DHS will investigate the incident with the job seeker. So this is where they have to make their contact and they have to determine whether a reasonable excuse existed. And then they'll book another appointment with their provider for them to sign the job plan. If the first failure was applied, so if Centrelink determined that there was no reasonable excuse for the unemployed worker failing to enter into the job plan, and they apply the first failure, and the job seeker again refuses to enter into or vary their job plan, an ongoing failure to meet a condition of their payment may exist. And what happens then, if DHS then confirms that on that second refusal, then the job seeker's payment may be cancelled from the date of that second refusal. So this is quite a complicated one because there's a few different interpretations about when that second refusal occurs. And a lot of job agencies, if you fail to enter into your job plan at your first appointment, then they'll schedule another appointment 2 days later, and they'll give you what's called 48 hours think time. They'll give you 2 days, and then they'll request you to come back in 2 days later and then enter into that job plan. And if you don't enter into that job plan, they'll say, well, this is your second refusal, and then they'll threaten you with cancelling your payment. But the Unemployed Workers Union has a different take on this question, and we believe that you shouldn't be required to come in 48 hours after your first refusal because that's too many appointments in the month. You're only required to attend appointments once a month if you're with Job Active, or once a fortnight if you're with a DES agency, and once a month also for CDP unemployed workers. So what should really happen there is you should be presented the job plan on your first appointment, and then you should have the right to discuss that job plan once more at your next appointment, which should be a month away if you're with Job Active or CDP, or 2 weeks away if you're with DES, or when that's negotiated. This penalty about refusing to enter into a job plan is one of the most important because, as we discussed in part 2 and 3, the job plan is really the central battleground between the job agency and the unemployed worker. It's where the terms are set about what the mutual obligation requirements of an unemployed worker is, and it's the belief of the Unemployed Workers Union that the vast majority of job plans are unfair, and they're basically making unemployed workers think that they have more requirements to do than they actually should have. So we really need to be very clear about what the rights unemployed workers have around signing a job plan, and make sure that job agencies can't just bully their way to, or bully unemployed workers into signing unfair job plans. And this is the penalty that job agencies use to bully people to signing a job plan that may be unfair. So we have contacted the Department of Employment around this issue, and we were informed that you can only be penalised for refusing to sign a job plan at all. So essentially, if you're saying that I'm not refusing to sign a job plan, I'm refusing to sign this particular job plan because I don't agree with this point that you're trying to force me to sign. So you're allowed to negotiate and renegotiate a job plan as long as you stay within the guidelines and the deed. So if you object to a section of your job plan because you think it's outside the guidelines and the deed, it's asking you to do too much, then you can negotiate within those parameters set by the guidelines and the deed. And the job agency can't penalise you for that. But if they do penalise you for that, and they essentially refuse to negotiate with you, then at that point you contact the Department of Employment and you lodge a formal complaint. And once that complaint is lodged, the Department of Employment will then mediate between the job agency and the unemployed worker to try to work out a solution to the problem. And This is a very fraught process, of course, as the Department of Employment have lots of a huge conflict of interest in their role as the regulator, but it's how the system is designed to work, and that's basically one of the roles of the Unemployed Workers Union, is to ensure the system is working at least how it's designed to work, so unemployed workers have a bit of say when it comes to the creation of a job plan. So essentially, we need to inform unemployed workers of this point and say that you can negotiate and renegotiate job plans, provided what you're asking for is within the deeds and the guidelines, and that's the work we do. And you shouldn't be penalised for that. But if they do threaten to penalise you, then you must make a complaint as soon as possible. And you must take it very seriously as well, because you could have a cancellation of your payment, which is a very serious penalty, because a cancellation of your payment essentially means that you have to go reapply for the dole, which can take sometimes as long as 3 months to get back on. So very serious penalty there, and we must encourage people who call the hotline to be very quick in their complaint so that they don't face a cancellation. The next penalty I'm going to talk about is the failure to meet job search requirements. So this is another participation report that's sent through by the job agencies to Centrelink. And providers submit this report when they have assessed and recorded that the job seeker's job search efforts are unsatisfactory for the job search period. So essentially, if the unemployed workers failed to meet the requirements of their job search requirements set out in the job plan. Centrelink will then investigate that participation report, so they would contact the unemployed worker to ensure that there's no reasonable excuse. And then if that penalty is applied, the job seeker may need to complete a job seeker diary for up to 12 weeks and return that to Centrelink. So this is quite a less serious penalty. It involves 12 weeks of filling out a job search diary. So instead of reporting your job searches to your job agency, you'd have to return your job searches to Centrelink in a job search diary. The next type of penalty I'm going to talk about is the no-show, no-pay participation report. And this is the most common of financial penalty that unemployed workers would receive. And of the 2.1 million penalties imposed upon unemployed workers, 300 or so thousand are financial penalties. So there are a lot of people getting financial penalties at the moment, and chances are their financial penalty is no-show, no-pay participation report. The first participation report is the failure to attend an activity recorded in the job plan without a valid reason or reasonable excuse. This is the most common no-show, no-pay penalty, as it applies when people don't attend their job agency appointments. So what happens here with this penalty is, much like the previous penalty I discussed about not attending an appointment with a third party, the DHS will suspend the job seeker's income support payment until the job seeker agrees to attend a re-engagement appointment and set that re-engagement appointment through their job agency. So then, at that point, if the job agency fails to attend that re-engagement appointment, then a no-show, no-pay penalty would apply. And the no-show, no-pay penalty is 1/10 of the job seeker's fortnightly income support payment for every day until they attend that re-engagement appointment. So that's roughly about $55, 10% of your payment, because the way they look at it is that each weekday is 10%, because there are 5 weekdays in each week, so they see, well, there's 10 weekdays with each fortnightly payment. So if you fail to engage with one of those days, then that day's payment is cut, which is they see as 10%, so around $55. And you'll keep on losing a day's pay until you attend that re-engagement appointment. So this is a really serious penalty, because if people aren't aware that they're facing a no-show, no-pay penalty, then they'll just keep on losing money. And I'm sure there are cases where unemployed workers have just lost days and days and days of their income support. This is why it's so important that unemployed workers understand what penalties they're facing and they re-engage as quick as possible. So our role in the Unemployed Workers Union hotline and our advocacy services is really just to inform people that they must re-engage as soon as possible, and then if they want to complain to the Department of Employment about what they regard as unfair treatment, then they can do that as well. But re-engagement always has to be the priority when we're dealing with unemployed workers who are facing financial penalties. So the next no-show, no-pay penalty is the failure to behave appropriately in an activity recorded in their job plan. This is a particularly outrageous penalty because what's considered appropriate behaviour is very, very vague, and the definition is so vague that job agencies can just use their discretion when it comes to imposing this penalty. And we've heard cases of unemployed people being told they're behaving appropriately simply because they're listening to music at their work for the dollar activity or while they're looking for work on the computers, and they face a $50 fine essentially for doing that. So it gives enormous power to job agencies. But in that case that I mentioned of someone getting fined for listening to music, they appealed that penalty and they end up getting that money back. But one of the main problems around appealing no-show, no-pay penalties is that the money's already taken out and then you have to appeal and try and get that money back. So there's this ongoing problem with the Social Security system where people on Social Security are considered guilty in the first instance, and then it's up to them to prove that they're innocent. So the idea of being innocent till proven guilty doesn't apply really to Social Security, and we believe that's hugely unfair, and it's a breach of natural justice, and we're looking into our legal options about that. But another thing to remember about no-show, no-pay penalties is that the actual deduction, the financial deduction, currently it doesn't occur within that payment that the no-show, no-pay penalty occurs. The money is taken out of the following payment. So let's say you face a no-show, no-pay penalty for failing to behave appropriately in an activity in your job plan. The money will be taken out not of your next payment, but actually the payment after that. The most concerning aspect about this penalty is that job agencies are not required to contact the unemployed worker to see if a reasonable excuse exists, which means that job agencies have complete say over whether or not an unemployed worker behaved appropriately or not. The only way an unemployed worker can really put their side of the story over to the job agency is when they appeal. And this, as I just discussed, can take a long time. And in the case that we saw, it took almost 2 to 3 months for the unemployed worker to actually get that money paid back. So it's a hugely unjust system in that way, and it's something that we have to be really aware of. So when we're dealing with unemployed workers facing these penalties, that we inform them of all these aspects. Of course, this is completely deliberate. It's all part of the punitive approach of this government towards unemployed workers. The next penalty in this section is the failure to attend a job interview without a valid reason or reasonable excuse. So this applies to unemployed workers who have a job interview, obviously, and are unable to attend for whatever reason, and then the job agency refuses that excuse or doesn't ask for an excuse, and then that's kicked up to Centrelink, who then investigate it. Once again, that's a deduction of a business day's payment until they re-engage. So until the unemployed worker contacts the job agency and then attends a re-engagement appointment, or alternatively works out with the employer to attend another job interview. The final no-show, no-pay participation report is the failure to behave appropriately at a job interview. And that's fairly self-explanatory. But once again, huge issues around discretion here, where employers and job agencies essentially use their own discretion to determine what is and isn't appropriate and there's huge issues around that. And much like the other penalty around appropriate behaviour, there's no attempt needed to be made here by job agencies to see if there's a reasonable excuse. Simply, you either were behaving appropriately or weren't, and there's no room to move. Job agencies do not contact unemployed workers and aren't required to see if a reasonable excuse exists, which is a huge attack on unemployed workers. The next type of penalty is the serious failure participation report. And these are the, as you can tell, very, very serious penalties. And we have to really, really be careful when we're dealing with people who may face one of these penalties. So the first penalty is failure to accept a suitable job without a valid reason or reasonable excuse. This penalty, much like all the other penalties, involves unemployed workers informing the job agency of their reasonable excuse, but then the job agency doesn't agree or doesn't give the unemployed worker an opportunity to give their reasonable excuse, and then Centrelink are involved. And then they, once again, try to see if there's a reasonable excuse. With this penalty, it's important to inform unemployed workers of their right not to attend unsuitable work, and the definition of suitable work is very, very specific, and it's quite wide-ranging as well. It goes across a range of different aspects that mean a job might not be suitable for a particular person, so that's the important thing to consider in regards to that penalty. And unemployed workers who face this penalty will potentially be hit with an 8-week non-payment penalty, which is an outrageous penalty to be inflicting on unemployed workers who are living on Newstart, which, as we discussed in part 1, is a payment that's $380 per fortnight below the poverty line. There is a waiver that is applicable to people who face this penalty, and that waiver is put in place when Centrelink essentially decide that the 8-week non-payment penalty period is too harsh and will cause undue financial distress for the unemployed worker. So that's an important right that unemployed workers have when they face a serious failure participation report, is that they can be given a waiver, and that waiver, as it says at the bottom of this slide here, means that they have to undertake a compliance activity for 8 weeks, which is generally a work for the dole type activity, which is still really, really punitive. Essentially, it's like something you would have to attend if you're on parole or something like that, but it's important that unemployed workers are informed of that so that they can hopefully avoid the 8-week non-payment penalty. This waiver, of course, is something that the coalition government are trying to get rid of. The next serious failure participation report is the failure to commence a suitable job without a valid reason or reasonable excuse, and this is very similar to the previous penalty and relates to that definition around suitable work, and that's what people working the hotline would need to be aware of. And it's important to mention that the definition of suitable work, as well as a range of other concepts, are all available in the Unemployed Workers Union's Unemployed Workers' Rights booklet, which is available on our website. The next penalty we're going to talk about is the last group of penalties, and it's called the unemployment non-payment period. And this is the most serious of all penalties because it involves 12-week non-payment period. There are two different types of penalties that are involved in the unemployment non-payment period. Both of them revolve around, once again, the definition of suitable work. The first applies to unemployed workers who voluntarily leave a suitable job without a valid reason, and secondly, unemployed workers who are dismissed for misconduct from a suitable job. And as it says here on the slide, which was taken from the Job Seeker Compliance Framework Guideline, a 12-week unemployment non-payment period may apply to job seekers who have received assistance to relocate under the Relocation Assistance to take up a job program, but the job seeker does not commence in that job. So essentially, if unemployed workers are part of this relocation assistance program, they're more likely to face a 12-week unemployment non-payment period. So that's the final penalty that unemployed workers can face, and you can really see how many different types of penalties that exist, and most alarmingly, the discretion that job agencies and Centrelink are given to inflict these penalties. And there's so much onus in this system on unemployed workers appealing and fighting back against unfair penalties. Centrelink and job agencies, of course, hope that unemployed workers don't bother appealing because that's just more work for them. But one of the most important things that the Unemployed Workers Union needs to do with our advocacy work is encouraging people to appeal, encouraging people to contact their job agency and dispute the penalty and put their front foot forward in giving their reasonable excuse. Or if it happens before, if they can't attend, calling up and giving a valid reason, because being cut off is a complete disaster in many cases for unemployed workers. So we need to be advocating and educating people on what the compliance system is and how it works.